This information is for general information purposes only and should not be considered legal advice. No one should act or refrain from acting based on the contents of this podcast without obtaining professional legal advice. This may be considered attorney advertising. Prior results do not guarantee a similar outcome. Hello and welcome back. I'm Eric Sunset, your host of the Doc Buddy Journal. Here at Doc Buddy, we deliver healthcare solutions that take the pain and cost out of broken workflows. From the ASC to the clinic to on-call at the hospital, Doc Buddy helps providers access, create, and move data seamlessly, all from the point of care. You can learn more about all of our solutions and set up a demo at docbuddy.com. Today, we've got a special guest. We're joined by Nicholas Alarif, who is a partner at McDermott Will Emery's Washington, D.C. office. His practice is focused on healthcare regulatory, fraud, and abuse matters, including the Physician Self-Referral Law, commonly known as the Stark Law, False Claims Act, the federal Anti-Kickback Statutes, and other healthcare compliance matters. Nick also advises clients on the complex legal and factual issues surrounding Medicare Parts A through D reimbursements and other CMS services payment policies. Nick, thanks for joining us.
Eric, thanks for having me. And looking forward to this conversation and talking everybody's favorite subject matter, Stark compliance, right?
There's a lot of layers to that onion. Absolutely. And this audience should be aware of all of the intricacies of the Stark Law operating physician organizations, obviously. So we got a pretty good look at your professional rundown there. What else should listeners know about you?
Yeah, no, sure. So just a little bit about my background. I've done the big three from a health counseling perspective, as I like to call it. I started out in government at the Centers for Medicare and Medicaid Services, as well as the Department of Health and Human Services, regulating the industry from a Stark Law, fraud and abuse perspective, and reimbursement perspective. Went in-house for a little bit and came back to the firm environment. So I've seen all the angles, and I'm happy to be back in McDermott here after a short stint in-house, although I loved in-house as well.
It gives you a great perspective, having seen it from all sides, like you said. Has it always been healthcare, or was there a path that brought you to healthcare?
Yeah, no. So my dad was a doctor. Grew up in a medical household. Did his billing, sort of. He would argue on that, but was really interested in actually government contract law, which led me in law school to the False Claims Act, which brought me back to healthcare. So it's been a circular path, but all roads lead back to our wonderful health payment system. So,
and we're together today. As listeners of the show will know, Doc Buddy will be attending McDermott Will Emery's PPM and ASC Symposium in Nashville next week, which is going to be a great event. And you're a speaker on a panel, Critical Strategies for Improving the PPM's Bottom Line, which is on Thursday at 2:00 Nashville time. So without spoiling the panel, obviously, what are you hoping some of the key takeaways for the audience will be?
Yeah, no, I think it will be a great, fantastic panel. We are going to be hosting some of the largest PPM platforms for specialty care in urology and gastroenterology. Some leaders of those organizations will be just talking about their experience from a strategy perspective, what they're doing in this current financial market as it exists, and some strategies they're taking advantage of. Also going to have great McDermott speakers outside of me. Joe Parisi is going to be leading that panel, and he's going to, I think, kind of just try and peel back the onion on what folks are just doing to deal with and grow their platforms again in this environment we're in, where it may be harder to do some of that acquisitional strategy, and so you're kind of growing from within. And I think some of our panel speakers will talk more about what they're doing.
And that's so timely. I mean, the title of the panel, Critical Strategies for Improving the PPM's Bottom Line, all come out and say it. Huge financial pressure on physician organizations, reimbursements falling, you can't hire and retain staff. There's a lot of headwinds in this space. So these physician organizations and PPMs scratching and clawing to keep the lights on in some instances while still delivering outstanding patient care. We talked before recording about some of the right ways to structure ancillary revenue streams. Because, as you said, sort of transactional growth or inorganic growth is a little tricky in the broader economic climate today. So, what is the right way to structure ancillary revenue streams without going afoul of any laws or regulations?
Yeah, no, that's a great question. And I think something that organizations can really leverage internally right now, if done the correct way. So, of course, I'm coming up from it at it from a health regulatory perspective. That's what I do. And when you're talking about ancillary revenue, for instance, clinical laboratory services, your diagnostic imaging, if you're in an orthopedic type of environment, your DMEPOS type things, all of those services, if they're paid for by Medicare, are going to be covered by the Stark Law. And even outside of those ancillary services, you may be running into the Anti-Kickback Statutes. So that's all big, bad, and scary, with regard to False Claims Act liability and criminal liability if you're under the Anti-Kickback Statute regime, which you are. But there are ways to do all these things, I think, in a way that mitigates risk from both those laws and can create real physician alignment with the organization, achieving the goals. And so, that's something that I'm hoping to talk about on that panel, bringing it back there, is what are some of those things that you could do? And one of those things is a lot of our clinics and ASCs are becoming clients, and PPM platforms that have those types of entities are, I don't think it's a secret, we're seeing bigger and bigger platforms. We're seeing doctors that don't necessarily want to get aligned with a hospital system, seeing a PPM as a viable alternative that will help them grow, with sometimes the help of outside investors. And what we have seen are some in recent years helpful guidance from CMS, which sounds like an oxymoron, but helpful guidance from CMS that allows for structures that can facilitate effective use of ancillaries, such as a clinical laboratory, which can sit under what may have been multiple practices that have come together. And so now you get those economies of scale, and that allows for physicians to effectively, potentially, share in that profit stream, which may not have been as clinically integrated before. Now with some of this guidance, if you structure it correctly, you can really take advantage of those income streams and lower the overhead costs of providing those ancillary services to your clinic base. So I think those are that's an exciting development. Some other things that we are talking about a lot with our clients right now is how we distribute and can share ancillary profits with them in a way that incentivizes them to be productive, but also is compliant with the law, which is tough to do. But there are ways that, the Stark Law, we usually have clinics and practices that are structuring themselves to meet what we call the in-office ancillary services exception. And I think one of the big things that you can do is, as long as the profits indirectly relate to the volume or value of referrals, you can have some strategies that will allow physicians to benefit from those ancillary profit lines. And so that's something we work with clients all the time on, is how we do that in a way that's regulatory compliant, but achieves the business goals of the organization, keep the lights on.
And I would imagine in a lot of ways too that if you're doing so compliantly, being able to access those ancillary revenue streams, that has to go a long way towards patient outcomes as well. If your services are all provided out of under one roof, as it were. Do you hear any feedback from clients on that?
Yeah, no, it's a great point, Eric. Like, there's a lot of when you have that continuity, you, I think, are providing a patient experience that is a lot more integrated and easier to access, and it's kind of becomes more of a one-stop shop. And with the change from, I would say, generally um, a more outpatient-based centric payment, the old payment incentives to do services in the hospital is just disappearing. And we're seeing all these services that used to only be done in a hospital really be done in the clinic setting. And so I think that that's a win-win for everybody. That allows for that's less expensive to the government. That allows for more control by physicians to produce those outcomes that I think make care easier to achieve to get from a patient, and not require them to go to 10 different places to get what they need.
Well, I think that's particularly interesting and timely too, because there's sort of a duality of medicine when you're face to face with a provider as a patient. It's all about you, as it should be too, by the way, in my opinion. When you're faced with a provider and you're their patient, it's all about you and your outcome and what can we do to get you moving better or feeling better or cure what ails you, right? But there's the other side of the coin where the lights have to remain on because at the end of the day, medicine is a business. Otherwise, you will not be getting any treatment, period. But then the bigger picture is what you just hit on is that triple aim of healthcare, good for the patient, good for the providers, and then good for the system. We're having a sort of Medicare focused talk today, but payers as a whole are the third leg of that stool, really. And it's high time that we address it as it is. It's no longer how the sausage is made. If you like me as your provider so much, well, I need to have patients that I get reimbursement for. So hopefully it's a broader shift in the marketplace than what I'm just seeing from where I sit.
Yeah, no, that's a great point. I hope you're right that we're getting that alignment, keeping the lights on, and everybody's happier, and hope that trend continues.
Yeah, it's high time. We don't have to throw any of the stats or figures out there about how much America spends on healthcare as a whole and as a percent of GDP, but something needs to change, and hopefully we're moving in that direction. So to bring us back to our central theme here, we talked a little bit about Stark Law and anti-kickback with the right way to structure these ancillary revenue streams. Maybe for those that need a little bit of refresher, Stark Law and anti-kickback get thrown around an awful lot, but maybe listeners don't know exactly what it is that's being referred to. Can you give us the 30,000-foot view here on what we're actually talking about?
Yeah, no, I'll do my best. So what we're really talking about are some very old laws at this point. I think the anti-kickback statute, for instance, is 50. It's been with us for at least 50 years now. Stark Law first came about in the 90s. It's had a couple iterations. At the end of the day, these are two laws that are getting at conflicts of interest, whether rightly or wrongly, that the government identified as potentially creating risk from a financial alignment perspective, with physicians making referrals for services payable by these federal healthcare programs to entities that they have a financial interest with, rather than what may be necessarily the best place for a patient to get care. And so that's the policy behind the pros that we have, which are very, very wonky, especially with the Stark Law. The main difference between the two laws is the kickback statute applies to everybody, and it's a criminal law. It is intent-based, which means that you have to mean to violate it. And with that, though, comes potential criminal liability, which I think is scary for a lot of people. But that is not typically where how we, although there are plenty of criminal enforcement actions with the anti-kickback statute, I'd say we more see it in the civil side, where it's the predicate case for a False Claims Act case which is kind of a whistleblower type case. That's how the anti-kickback statute and the Stark law are typically enforced, is that a whistleblower will say, I know you violated those laws. I'm going to bring a case in their name, and I get to collect some of that money, whether the government ends up bringing it for me or I bring it myself. So that's the kickback statute, intent-based, applies to everybody. Stark law is a little different. Pete Stark is the founding father, so to speak, of that. He saw that the kickback statute, more or less, was not hitting everything he thought it was, and so he said, well, what would really work would be a strict liability law, meaning there's no intent that anybody has to prove. So if we have a physician that makes a referral for a quote unquote designated health service, which is really typically what we're talking about, those ancillaries, is what I was getting at. They make a referral to an entity with which they have some type of financial relationship, whether that be ownership, whether that be just a call coverage arrangement. They make a referral for the designated health service. They've got to meet an exception to the Stark law. Basically, a formula for how that financial relationship typically has to work. So is the compensation that the physician's receiving fair market value? Is the arrangement in writing? Is it signed by the parties? A lot of those are requirements for compensation arrangements. When we're in the clinic space, we are dealing a lot of times with a physician that owns their own entity that's billing for the designated health service, right? So I think one common misconception is that the Stark law doesn't apply to clinic services potentially, and that it only if I own my own practice and I bill for an ancillary service that's a designated health service, it's not really affecting me. Well, that's unfortunately not true. Stark law is extremely intrusive into how physicians go and compensate themselves. So we need to be very wary of making sure we structure compensation arrangements to meet an exception to the Stark law. And there is a huge one that everybody uses for purposes of protecting that ownership interest the physician has in their clinic. It's called the in-office ancillary services exception. So that's probably more than you wanted to know. And I hope I didn't put everybody to sleep with that diatribe.
No, but it's mission critical. I mean, nobody, at least I think most people don't go through their day thinking about laws on the books, whether you're a physician and you're thinking about Stark law day in and day out or whatever else it may be. But you need to be aware of these things. You're operating a business, and to run afoul of Stark law and anti-kickback, especially with the liability basis of the Stark law versus the intent base of the anti-kickback statutes, that's a big deal. And businesses, like we said, this is how the sausage is made. Medicine is a business. You must be aware of these things. And kind of to that point, Nick, what are some of the common mistakes that happen, either that you see or that are more broad as a common mistake running afoul of Stark law?
Yeah. So I really do a lot of work on the physician practice acquisition side of the house here at the firm. I do a lot of transactional support, basically being a glorified housing inspector when it comes to making sure that whatever somebody's buying, whether it be a clinic, ASC, that we all the pipes are in order, everything's working correctly. And from a clinic perspective, what I see a lot of times when one of our clients would like to purchase or invest in through an MSO, or depending on the corporate practice of medicine considerations, would like to invest in a practice, what I see a lot of times running afoul from a Stark law perspective is how physicians compensate themselves. Now, this is the issue we see a lot of is physicians being paid on I'll call it an eat what you treat model that pays physicians based on a percentage of all the revenues and doesn't treat the ancillary services or the designated health services any differently than how they treat everything else. I said eat what you treat. Some people say eat what you kill. I think medicine, eat what you treat, sounds a little bit nicer, right? Um, so that's a common mistake we see where, because, and you're like, well, why does that sound? Why is it? That sounds pretty normal, right? Like, shouldn't people be paid for what they're doing? And it gets nuanced. If it's all based on the personally performed services of a physician, it can be okay. But the minute that you have a physician getting paid for services that maybe they order, even though you may think, oh, I'm personally performing it. If you have somebody else do a certain service that is a designated health service, and the way that that physician is getting compensated, it takes into account directly their referrals they make for that service. We've got to think if there's a Stark Law kind of exception that is available to protect that type of arrangement. And sometimes there isn't. Sometimes there is. Depends on the size, scope of the practice. But that's probably the most common mistake I see. And a lot of times we are working with either our client to fix those types of arrangements, and they are fixable, and there's ways to mitigate any risks surrounding these. It's very routine because it is such a common mistake, potentially. So a lot of times we're working on that side of the house, either for a client buying a practice or when we're working directly with a client to fix those things. Maybe they're getting ready for a transaction. Maybe they just don't want to have this regulatory risk hanging out there. So that is, I would say, the most common mistake in the clinic perspective from a Stark Law angle.
Well, let's go to the other end of the spectrum too, and I'll paint just a really short picture from my days in the revenue cycle space. That when you're looking at billing and coding, there are certainly those that will abuse that system and they will get their just desserts. But then there's the other end of the spectrum that's overly cautious. And interestingly, if you're a chronic undercoder,
Yeah.
the payers and Medicare are going to have a similar conversation to those that are more aggressive in their coding, going, "What are you doing? You're not treating anybody with any degree of severity. Like, what are you on our panel for?" I mean, they do that out of an abundance of caution. If I just undercode everything, nobody's going to be looking at me, and I'll be okay. And they, at its core, are leaving money on the table, and they're also not adhering to the contracts in place with a given payer, which is not good. What are some of the misconceptions around Stark Law where folks are overly cautious and it's either hurting their top line or bottom line, or it limits their ability to treat patients how they maybe would really want to?
Yeah. Oh, wow. So I will say, Eric, a great question here, that unfortunately, for better or worse, some might say the Stark Law is a lot of form over substance. And sometimes when we're doing these analyses, because again, it's a strict liability law, it is just you have to meet these requirements. It doesn't matter what your intent is. Again, so a lot of times people will say, well, I don't want to deal with DHS and Stark Law ancillaries, so I'm just going to pay physicians nothing related to the profits of what they, maybe I'm an owner of a practice and I have a bunch of employed physicians. I'm just going to pay them only on their personally performed service, nothing else, just a WRVU type calculation. And the answer there is, if you meet the group practice definition, which is very complex under the Stark Law, and you can take advantage of the in-office exception, which is again what we typically use, you can share profits with your employed physicians, with your independent contractors, even from those designated health services. It just has to be done in a way that doesn't directly take into account the referrals. And CMS has basically given some look, you do it this way, you're safe type scenarios. And it doesn't mean you have to do it that way, but there are ways you can share those profits with those individuals to incentivize them, to align them with the keeping the lights on of the organization. And so it doesn't need to be this all or nothing type of approach. We can do things to align physicians that aren't directly related to their referrals, but certainly will get those physicians to be incentivized to provide care to patients and be productive.
Well, that makes sense. And when you look at some of the newer data around physician burnout, like a lack of autonomy is a self-reported driver of burnout. We know we're kind of on this precipice of a shortage of physicians that's going to be a cataclysm in the next 5 to 10 years. From retiring early, not wanting to put up with all of the red tape, not wanting to put up with the bad technology in use. So I think that's really timely. And to bring it back to the panel, critical strategies for improving the PPM's bottom line and by extension, the physician organization's bottom line. Just one quick thought on human nature. If I'm a Powerball winner tomorrow, I'm thinking about a tea time. I'm not thinking about work, right? Like you potentially rather be on the beach. There's certainly those that rather build your Elon Musks, your Bill Gates. They're just on this earth for one thing and one thing only. And that's great. Glad we have folks like that. But I think for the most part, you're doing a job so that you can have the lifestyle that you want. And lifestyles obviously are not free. They cost money. So it's a really long walk for kind of a short drink of water. That when we're looking at ways to increase revenue and be able to treat as many patients as your panel and the hours in the day allows, there's some interesting things happening around value based care where Stark Law and these anti kickback statutes, which love them or hate them, they're there. They're there for a reason. They may allow for some new payment mechanisms. So, what are you seeing on that front?
Yeah, yeah, and this is just a hot topic all over healthcare. It's a hot topic, I think, at some level because value-based care can mean a lot of things to a lot of different people. Um, so pick your definition. When I talk about value-based care in my practice, I'm talking about some really cool developments that have occurred recently on a Stark line anti-kickback side. Last couple of years, it was a big rule change where we saw the introduction of some new exceptions to the Stark Law and new safe harbors to the anti-kickback statute that allow for new payment models to flourish and not run afoul of these. Again, as I noted, these are kind of old laws. They were developed during a fee-for-service system of care. Pay you refer a patient, you get paid. Refer a patient, you get paid. That's how it worked. So the laws are designed to in that kind of world. We move from that. Now we're talking about the triple, quadruple aims and how we're supposed to and I think quality is and continuity of care. These are all really important topics and really important to providing care in a way that makes sense, that is smart, not just formulaic. So these new safe harbors and exceptions, I mean, from my perspective, the Stark Law exceptions really are an interesting development for clinics to really think about, for practices to really think about, because I was talking to you about those volume value kind of strictures that exist, that you can't pay physicians directly based on the volume or value of their referrals, that a lot of the exceptions require that compensation be fair market value, right? These are big constraints, especially in potentially a value-based care scenario where you may be paid based on ordering a certain test that is in the best interest of a patient, but maybe that test is DHS, it's that ancillary. But that's what you should be doing. That's the standard of care. So the Stark Law exceptions, for instance, recognize this and allow, if you meet quote unquote certain regulatory requirements of being a value-based enterprise and hitting a value-based purpose, if you do all those things, you meet the exception, you meet the definitions, you can pay physicians to align to achieve those value-based purposes based on the volume or value of a physician's DHS referrals. Doesn't necessarily have to be fair market value if it's achieving and moving towards value-based care. And I'm throwing these terms around without very good definitions of what is value-based care. What is a value-based purpose? Well, the thing is, CMS also didn't give very strict definitions here, and that was on purpose. And that's because it could be so many different things. It may be that there's a guideline that is really important that in orthopedics that needs to be that's really beneficial for increasing outcomes for a particular surgery. Maybe you are ordering X, Y, and Z tests that really help with the potential after a hip replacement or something that stops them from going back to the hospital and impacts or increases their the effectiveness of that surgery. Maybe that's physical therapy. Maybe it's something that would otherwise be a DHS. If you are structuring this for a particular patient population in a way that enhances that value-based care, CMS basically said, here are the keys. Do your own models. Show us how these financial alignments will achieve those value-based purposes, and we're not going to bother you with the Stark law. Maybe and I think that is really something interesting that a lot of clinics and practices could start thinking about taking advantage of, whether that's internal with some of your employed physicians, whether that's with a hospital system. There's just a lot of opportunities, I believe, to take advantage of these new exceptions and safe harbors that have been promulgated by the Department of Health and Human Services.
And then I can't imagine having recently written laws on the books that were accidental in their loose language. I think that shows some good foresight, maybe some lessons learned from something like the High Tech Act and the meaningful use. So glad to hear that. That's got to be gratifying for you in the seat you sit in.
It's fun to help clients with it too. I mean, it's just saying being able to help them actually move goalposts for patient care. And not have these laws that are a lot of times been a hindrance to them be potentially like, well, we have a solution for that. It is gratifying. It is really great to not always be the no guy.
Well, the old saying, you don't generally retain a lawyer to not take their advice. So that's good for all parties concerned. And then just a quick note, it is tough to pin down what value-based care is or isn't. What do you mean when you say value-based care? Well, it's different from what I thought it was. But we've been talking about the PPM and ASC Symposium, which is Wednesday and Thursday next week. So that's May 15th and 16th in Nashville. There's also a value-based care symposium happening that Friday, also at the Omni in Nashville, hosted by McDermott Will Emery. For those interested, we'll have a link to that event in the show notes as well, separate from the PPM and ASC Symposium that Nick is speaking at. Do you have any part to play in the value-based care day on Friday?
Just promoting it. Like I said, this is a really broad topic, and it means a lot of things. And so we have, from my fraud and abuse perspective, these exceptions and safe harbors are really important for value-based care, but there's just broader trends out in the industry for both managed care, maybe and risk models, and how the shift to value-based care is affecting those as well. And so I think the goal of these two symposiums being back to back is really to cover all the different ways that value-based care can be impacting different types of organizations, both clinics, ASCs, practices, payers, hospital systems. So yeah, that all I can say is I think going to both and getting flavor for both will give you a really good view as to what's happening across the value-based care spectrum.
Yeah, you definitely end up more educated than most by attending each of these. So value-based care, obviously a hot topic. I'm not sure, though, that there's a hotter topic in healthcare right now than that of artificial intelligence, or so-called artificial intelligence. What kind of thoughts do you have on the topic, Nick?
I mean, I think it is absolutely fascinating. It is, I mean, I can only speak to it more from a layperson's perspective and the impacts there. Some of our clients, obviously, especially in the laboratory space, have been doing this for a while, where they've used AI in some capacity to create a better mousetrap for diagnostic tests to predict, for instance, certain types of cancers or those types of things. And so, I mean, where this goes, how that impacts physicians in how they make decisions and how they rely on AI, and what kind of laws spring up around that, in the future, I think a lot of times we see the legal environment in a game of catch up, kind of following the trends. And so, what does that look like? I'm just as intrigued as everybody else, and how AI can be leveraged in a more comprehensive capacity to achieve better patient outcomes, I think will be interesting. And then at the end of the day, how that plays into fraud and abuse. Oh my God, I have a few imaginative streams of how that could work. But that's, I think, for chapter 4 or 5, not even 1, 2, or 3.
Yep, I think you're right there, and I'll call it back out. So-called AI. I've got a little bit of experience in predictive analytics and machine learning, and for those concerned, we're headed towards like a Terminator, Skynet scenario with an uncontrolled artificial intelligence. We're a ways away from that. It's moving quickly, but we're quite some distance away from needing to worry about things of that nature. And then what you mentioned this too, generally or historically, medicine has been pretty slow to adopt really anything new. Cynically, in the early days of meaningful use, you'd hear from providers that if they could, they'd still be using like a quill and a scroll of papyrus to take patient notes. What do I need an EHR for? Just what am I doing there? Historically slow, but you're starting to see
The
some.
messenger back.
Yeah, yeah. What's interesting to me, though, is you're starting to see some consumer protection laws be drafted and proposed around the use of AI. Still haven't seen anything related to patient care. So I'm hopeful that we will have some forward-looking folks, in charge of drafting bills and laws like that. But we will see. It's moving very quickly.
Yeah, one can hope. It's tough to keep up with just how fast it's developing and how quickly those AI supposedly is increasing in its eye, so to speak.
And then Nick, as we kind of look to put a bow on this one here, what would be the one thing that if you could shout it from a mountaintop that every PPM, every ASC, any physician organization, if you could just send a thought out into the universe and have that be a takeaway, what do you wish everybody knew a little bit more about?
I mean, I think I would say Stark doesn't have to be scary, but that's a little personal. Like, we can get that alignment from a comp perspective. We can do it in a way that works. Don't And it's always better to plan in advance. It's easier to do things before they occur. So planning and being proactive in how you structure some type of compensation model or equity model. If we look at that at the beginning, we can likely get you where exactly, like 98 to 99% of what you want, maybe with a tweak here or there to deal with some of the regulatory constraints. So getting from, I'm obviously speaking from my little perch of healthcare regulatory advising. Getting in there early can save you a lot of heartache at the back end. So that would be my 2 cents there.
Stark doesn't have to be scary, and an ounce of prevention worth maybe 10 pounds of cure when we're talking about federal law. Just my opinion there. Nick, where else can folks connect with you? Are you big on any social media?
Yeah, I'm active on LinkedIn. That's probably better. Twitter, X, I not so much. I think LinkedIn is great. So if people want to connect, I'm always open to that. And again, if you're coming down to we'd love to see you in Nashville. So I hope you can come to our panel and stay for the Value Based Care Symposium. And if you're into behavioral health, there's going to be a great panel before us there. So yeah, hope to see folks soon.
Well, I'll definitely make it a point to track you down in Nashville. And if is there anything else you want listeners to know about what you're doing or what you have going on?
Just we're busy here always. There's whether that's transactional or just regulatory advice. I would say value-based care though is is something that we're seeing a lot of organizations interested in looking at as avenues to achieve their alignment goals. And so I would say keep an eye on that. Well, we will, I think, see more and more interest generally from the public on those fronts. So value-based care, I'm all about it, and I think folks, even if they don't think that they're part of value-based care, you absolutely can be, and what you're doing can be. So that would be my last thoughts there, Eric.
Well put, Nick. Thanks for the time. Really appreciate you joining the show today.
Yeah. The other thing I'll note is if folks are interested in getting keeping abreast of legal developments, we're seeing a lot of changes, both at a state level, from I'm sure folks have been listening to the non-compete talk coming out of the FTC, maybe of interest to folks. A lot of changes at the state level from a corporate practice of medicine perspective. A lot of interest generally about private equity at both the federal and state level and their involvement in healthcare. We are doing, as a firm, a whole lot of webinars in addition to the symposiums that we're doing in Nashville, and a lot of thought leadership articles on different subjects as they come out. So I'd also recommend folks click a follow on McDermott Health. Generally, not just me, but all my wonderful colleagues are doing great work on this space. I think we're doing we're following a lot of 340B developments as well. Everything you can think of on the topic of healthcare developments, our firm does a really great job of keeping the public informed of those happening. So please look into that as well.
We'll be sure that everything that we've referenced in this episode, the PPM and ASC Symposium, the Value Based Care Symposium, the link that Nick just referenced there, we'll make those all clickable in the show notes. They'll be easy to track down for listeners to engage with and follow and soak up as much information as they can. And on behalf of the entire Doc Buddy team, I want to thank you for listening. Be sure you're subscribed to Doc Buddy on Apple Podcasts, Spotify, and YouTube so you can always get the newest episodes of the show. Until next time, I'm your host, Eric. We'll talk to you soon.